When we talk about memorandum of association, when we talk about memorandum of association, uh, we talked about Section 4 of the Companies Act. Section 4 of the Companies Act talks about memorandum of association with respect to an incorporated company. So, if it's a limited liability company, they are basically talking about the fact that there are multiple clauses within the memorandum of association which deal with multiple uh, uh, sections which represent the constitution of the company. So, limited, the word limited, when you talk about what exactly is a company, whether it's a limited, public limited, a private limited, what exactly is the business form of the company, that is something that they mention in the name clause. The next clause is relating to the situation clause as to where a company is situated. Now, this is something which you have to have different for different companies. There can be multiple companies which can be public limited, there can be multiple companies private limited, but companies that have to have a certain registered office, it can't coincide with other registered office of other companies. So the idea is with respect to this situation clause is that the registered office is very specific to various companies, and based on that, do they maintain what exactly is the office for communications, either with the office of the ROC or with the office of the RD or with the office of any sort of official communications that need to be made. So a registered office is basically very important. The situation, always it may so happen, it may not be that every registered office of a company is the place of business for a company. It can differ, but nonetheless, there has to be a registered office of a company. The next is relating to objects clause of that particular company. Objects clause is basically the uh, things that a company can or cannot do. Now, the moment when we talk about what exactly can a person, can a particular company do with respect to the in its lifetime, this is the clause which basically talks about all the things that a company is empowered to do within its lifetime, within the time that it is going to be, it is a going concern until the time of winding up. Now, you may add things to it. You may want to add, usually when a company begins, incorporates itself, the objects clause is kept extremely fluid, it's completely diluted, but it can be made more expansive or more specific with respect to the company as and when the company is functioning. But for that, amendment has to be done. And we talk about the capital clause with respect to the kind of money, the nominal capital that a company has incorporated itself with, and what exactly are the number of shares that the company right now has, which it can issue. The next is with respect to the liability clause. Liability clause is whether a company is uh, a limited liability and unlimited liability, limited by shares, limited by guarantee, etc. We spoke about what ultra virus was. And then we talk about ultra virus is basically when you act outside the powers that are meant for you. And then we talk about articles of association. See, there can't be any misrepresentation whatsoever with respect to a particular company. Whatever you write in your memorandum, whatever you write in your articles, there can't be any misrepresentation per se. But the idea is that whenever you are writing something within your articles or memorandum, the idea is that you as a company, you are going to abide by it. So if you don't abide by it, then it becomes a bit of a problem, because it tantamounts to deceiving your shareholders, the people who actually believed in your charter documents, your memorandum, as well as your articles of association, and believed and became a part of your company by contributing money to the share capital of the company for it to run and achieve those objects. For a simple example, if there was a company which wanted to say they wanted to go and uh, it has to uh, the company has to what do you say uh, make malaria medicines. So you saw the objects of the company, and when you saw the objects of the company, you found it very altruistic, that you wanted to invest in the company because you believed in the ideals. Now, because the company did not want to go ahead, or they did not want to invest money in making medicines for malaria for that matter, and they wanted to maybe do something more profitable as a work, because maybe the amount of medicines that they might want to sell for malaria may not have such a huge market, or maybe it is not very profitable business. In such cases, if they don't do that, and if they do something which they have not committed to in their objects clause, it tantamounts to a deception. Is my voice fine? I think there has to be something to do with the reception. If you would just check. Now we begin with articles of association. Articles of associations is basically the bylaws and the laws of the company, which basically talk about what the company, how the company is supposed to run. So if you read Schedule 1, which is annexed to the Companies Act, if you see that, you'll actually be able to see there's a table F, which talks about the model articles of association. Every single time that a company needs to get incorporated, that is a table that they look towards in order to form their articles of association. Now, what does it contain? It may have everything which is very different from what is mentioned in the table F, but ideally, share capital, variations of rights, what sort of share capital will you be issuing? What exactly would be the kind of lien on shares that can be done? If you wanted to, if the company wanted to exercise its lien over the shares, right to retain, supposing if it's a partly paid up share, etc. What happens to calls on shares? If, say, supposing there are shares which still have certain calls that are due, transfer of shares, shares that could be transferred from one person to the next, transmission, where you have to, what do you say, uh, by inheritance. If there is a person who has, if I have bought a share, and say if I have a son, and today if I die, all my property will be bestowed upon my son by way of inheritance. That's normal. Now, share is a property, it's a movable property that has been mentioned under Section 40 of the Companies Act itself. So within that concept, the only thing is that the transfer of shares is something that is not done with respect to every other movable property. So Transfer of Property Act, Sale of Goods Act is not something that's applicable to share transfers, because you have a specific law for share transfers, shares of companies, and that's your company law. But barring that, every other share that you may think of is transferable by uh, what do you say? Uh, by virtue of transfer of property or sale of goods. So we're talking about India. So transmission is where, if I die, what happens to the shares that I own? So in such cases, will the shares be given to my son? What happens to the rights that I had with respect to those shares when I was a part of that company and no longer am a part of the company? Now my son happens to be a part of the company. So transmission is a concept that we will be encountering a little later. But just to give you an idea, if it's a private company, they may have certain restrictions as to these sort of transfers or transmission. Because private company at the very outset, like we said, is a company which is extremely possessive of its management. They don't want to dilute it at any cost. They don't want anybody to enter into that particular management if they don't like them, or if they have reasons to believe that the person may not be very good for the company or is will work contrary to the objects of the company. So in such cases, transmission of shares is something which they can govern in their articles of association if it's a private company. Public company, not so much. Maybe just an intimation needs to be given that the names of the parties needs to be changed with the depositories with respect to the new holder, the person who is now the new holder of shares. Ideally, this was the case when there were physical form of shares. Ideally, because when there are physical forms of shares which are materialized shares, not dematerialized shares, not electronic form, they had to be signed and given. But with respect to those sort of shares which are dematerialized right now, these days, say if a person was to die, if you talk about the various accounts of the person, the idea is that usually it can be taken care of through online, what do you say, intimations, or if at all, if it's a very big chunk of share, if it's a controlling stake in some company, that could be uh, intimated to the company. Today, God forbid, if Mukesh Ambani was to die, what would happen to his shares? So his shares would be something that would actually go to his children. And if it goes to his children, then under what circumstances will they become the new holder, or what sort of rights do you think they will get in order to run the companies where Mukesh Ambani used to hold a controlling stake? So when we talk about these sort of concepts in a company, because a company is an entity which has a perpetual succession. So you can't with the death of the members, the company doesn't come to an end. Company will only come to an end once it has been wound up. The operations have been wound up either by choice, by operation of law, by whatever reasons. But not before winding up does the company come to an end. So in order to maintain this perpetual succession of a company as opposed to a partnership, how do you maintain that the company will run and continue with its members? That's with the on the by virtue of shares. So shares is one thing that one particular uh, commodity which can help a company stay afloat for the rest of its life until it's wound up. Now, forfeiture of shares, alteration of capital. Forfeiture of shares can happen for very many reasons. One of the most rampant reasons happens to be if you don't pay up the calls which have been issued for a company. So if it's a partly paid up share, and if you don't pay up the entire amount of money. The next is with respect to your forfeiture regarding, say, supposing um, if somebody has, so basically when you become a shareholder, you subscribe to the charter documents of the company, the articles, as well as the memorandum. So by subscribing to these documents, the idea is that you will abide by these for the rest of your life. For the rest of your life, in the sense, for the rest of the time that you are holding those shares. You can't act beyond it. Now, one of the primary things in a company is that in a company, the decisions are usually taken by the board of directors, and it is the duty of every person in the company to abide by a board of directors resolution. So you can't act against it. But what if you did? What could be the repercussions? So in such cases, if you actually went beyond the what do you say? If you actually went beyond uh, uh, the board of directors resolutions, or board of against the board of directors resolutions, or say do something which is very patently against the company's documents, in such cases there can be a forfeiture of shares. The company can very well take you out of the company by forfeiting your shares and taking you out of the membership. But this is not something that is done at a drop of a hat. This is something that you can't do at all points of time if you as a company, if you wanted, because forfeiture is one of the biggest penalties. You understand, right to property is a constitutional right, and that includes the property that you have in shares. So today, if somebody has sold you a piece of land, they can't take back that piece of land just because they think you are not a correct holder or you're not a correct person to be holding that land. So there has to be very many what do you say, reasons for that. There has to be a very valid ground for taking you out of the membership of a company. So forfeiture of shares is one way of taking out, deregistering a person as a member of the company. So that has to be done on very, very what do you say? Uh, with There has to be, I mean, a very big caution has to be exercised for for the company which wants to do that, which wants to take that action against a member, and there has to be very good reasons for that. So if clearly it's written with respect to calls on shares which are not met, understandable, because it's within the contract. If you're not paid the full consideration for a particular property, it's liable to be forfeited. But with respect to anything else where, say, you have acted malified to the company, in such cases, forfeiture of shares is something which has to be done by very many reasons. Because as a member, it can be an oppression mismanagement claim for you to contest that you have been taken out of membership, which is under section 241 of your Companies Act. For you as a member, it can also be a concern with respect to section 5758, where the company refuses to register you as a member, despite the fact that you have paid in full the share price and all of that. So that is something which you will have to be very careful about. It usually comes up in problem-based questions. So you need to see. Alteration of share capital. If a company, see, every time that you frame the draft, the charter documents of a company, you have to uh, mention the share capital, the authorized share capital, and number of shares that you are trying to issue. But supposing if that particular, the shares that you are trying to issue, so basically when you write down the authorized capital of the company, that has to be, that will be something which will be liable to pay, you will be liable to pay a stamp duty on. So usually people don't keep a very big amount as authorized capital, because you're starting your company, you're incorporating a new company, a fresh company. You will not keep a share capital which, say, Adani or Reliance or one of those big conglomerates would have. You try to keep it small and increase as the time goes by, because you've just started with your business and you don't want to pay a lot of tax, stamp duty on that. So in such cases, your transmission, your capital clause will be limited to a certain amount of money. But as and when your company is growing, it's becoming bigger, then you will find out that you need to issue more and more shares. Shares at the end of the day is a liability for the company. But nonetheless, issuance of shares is one thing that a company does in order to maintain its perpetual succession, in order to acknowledge the fact that there can be people who would come with their 2 cents to contribute to the management of the company and run the company better. And there can be many other reasons why you would like to give shares or sell shares of a particular company. Say listing is something even private companies do these days. That's because they want to be in the limelight, or they want to earn that goodwill. And through that earning of goodwill, they want to uh, they want to earn that what do you say? They want to earn the trust and the faith of lenders, of creditors, financial creditors of the country or abroad. And because they are listed, etc., means that they have a strong corporate governance system. The fact that lenders, because lenders are only, they only care about their recovery. The money that they have given to you as loan, they just want that back. So if you have a good corporate governance, because clearly a creditor, unless there's an arrangement to the contrary, he can't be a part of your management, he can't vote in your meetings. So in such cases, if there is such a lender who is interested in giving you loans, he would also want to know what exactly is it that you do in the company for being assured of the fact that he will be getting the money back at some point of time. So in such cases, you might want to increase the share capital in order to go for a public offer to portray your company's goodwill or make a strong reputation in the market. Many things. Capitalization of profits, buyback of shares. These would also be with respect to what exactly do you do with the account which has your reserves or profits. What exactly is the money going to be utilized for? Buyback of shares, if the company decides to consolidate its shareholding and wants to delist or wants to buy back shares for whatever reasons, either to reduce the share capital or to, I don't know, or to reissue the same. For whatever reasons, buyback of shares is something that companies may try to do in order to avoid a hostile takeover. They might want to do it for very many reasons, basically. So, buyback of shares, the procedure would be mentioned within that Articles of Association for the shareholders to know that if today the company decides to do that, say the government of India wanted SAIL to buy back its shares because they wanted to get some money. So, what they did was, because obviously SAIL is a government company and majority of its shareholding is with the government still. So, they decided within the board meeting itself that there would be a buyback of shares that they would be announcing, based on which the government would sell their shares, get the money, and run its own business or run its own government machines, the state machinery. But SAIL would then have to buy back the shares, pay them the money, and because the dividend clearly wasn't enough, whenever SAIL would make a profit, they'd distribute the dividends, but clearly that much amount of dividend was not enough for the government. But they did it for the purposes that they could run the company, they could get the money from SAIL and could do their business more efficiently, whatever their business was. So that was mentioned within the Articles of Association. It can't be ultra virus for a company to buy back the shares. So there's a whole procedure under Section 62. We'll read about it with respect to buyback, 68, etc. 62, 68, and all of that. How will the company conduct its general meetings? And what would be the voting rights of proxies that can vote, as well as if the meeting is not held on time, there could be an adjournment. General meetings, not all general meetings are annual general meetings. Annual general is just one. So AGM, conducting an AGM, that's a statutory mandate for the company, which we will be discussing under Section 96 and 100. But how do you conduct it? How many days notice do you have to give to the members? Who all will be mandatorily invited for the general meeting? The directors, the auditors, as well as the shareholders. How many days notice? 21 days or more than that, 28 days, whatever. You would also talk about what needs to be discussed in that meeting. You don't call people for meeting and then you decide what to discuss in that meeting. Now the meetings can be held online, but prior to this, when there was no facility, there was very little information technology. People didn't have access to computers, internet, etc. Majority people, when they didn't, then they would have to call physical meetings. So in such cases, say a company like Reliance, which is as big as Reliance, they would have to, because their registered office is at Bombay, so they would have to conduct their general meetings at the place of the registered office of that particular company, usually at the registered office, but you can still have this leeway, because if the registered office is not as big to accommodate all the shareholders, you can have it in the place. So they'd have to book a Wankhede stadium to get all the shareholders from across the country, outside of whoever basically was a shareholder of that company, in order to attend the general meeting. So in AGM, most government companies, when you see how exactly do they conduct their meetings, you'd actually see on what basis are they conducting, how are the people coming together to attend the meetings. Everything is mentioned within your articles of association proceedings. Who's supposed to now? There is a way. There's a method of conducting it. Secretarial standards. So a CS is the one who's actually in charge of looking after the compliances. So whenever you talk about general meetings, board meetings, etc., minutes of meetings, proceedings at general meetings, it is always, see, you have to send out notices, everything, even if it goes under the signature of the directors. The idea is that the compliance needs to be maintained by the company secretary. So it is for the company secretary to ensure that every other standard has been maintained, because when there is a secretarial audit to that effect, and if it's found that a major chunk of shareholders have not been invited for the meeting and yet a general meeting was called, whether be it an extraordinary or an annual general meeting, then the company would actually be falling short of this sort of compliance and they can be held liable. Regardless of the fact, if the members who have not been invited for those sort of meetings, they can also ask for an oppression mismanagement claim where they are being strategically kept out of the decision making systems of the company. But barring that, this is one of the biggest fallacies that the company can be liable for. So the entire procedure is actually mentioned in Articles of Association, which is for the company to follow. The next is regarding proxies. If there's somebody else who has to vote for you, that's a proxy. Board of directors, proceedings of the board. Again, how many directors will you be having in your company? That is something that you will have to decide for as a company. Does anybody know what the maximum number of directors there can be in a company? The maximum number of directors that you can have in a company, according to Companies Act, is 15. Now, if you want to go beyond, there are procedures for that. But what the Act suggests is 15. Now, if 15 is the number of directors, the maximum number of directors that you have, which is permitted by the Companies Act, you as a company may choose to have anything less than that. But obviously, you have to fulfill the minimum number of directors. So, for a public company, supposing if there are 3 directors at minimum that you require, so you need to have at least 3, but you can have, say, 5, say 10. You may not have the whole 15 directors that is mandated by the company unless you want to. So, that has to be mentioned within the articles of association as to how many directors do you have vacant positions in your company, and what exactly is their method of conducting a meeting, and what exactly is the way that meetings for board of directors would be conducted within that particular company. Now, in a company, there are key managerial personnels. There's a concept of key managerial personnels under the Companies Act. If you see chief executive officer, the manager of a company, company secretary, chief financial officer, they are within the concept of a key managerial personnel. So though these people, who these people are, their positions, everything is mentioned within the articles of association. The company seal. What exactly is the company seal? It has been said that it's now an optional. Ever since 2015, April, this common seal of a company has been made optional. It has not been abolished, it has been made optional. Common seal is nothing but the signature of the company. And that signature of the company, it was very prone to being forged, because if there is a seal of a company, a certain stamp of a particular company, that stamp can actually be forged from anywhere. Once it's forged from anywhere, that particular stamp can be used for n number of contracts, and the company can be endlessly made liable for every single thing that the company may want to do. The others may want the company to do, or the company could be made liable. So in such cases, the seal, the common seal, is a particular, what do you say, is a signature of the company. Now, under Section 21 of the Companies Act, the seal has to be accompanied with the signatures. Signatures of whom? Signatures of, say, two directors at the same time, or say one director, one company secretary of the company, in order to show the authenticity of that company's seal, that the company now chooses to bind itself with certain contracts where the seal has been used. So it ensures that the company is not made liable for contracts that it never entered into. So this is something that they have actually spoken about. Now, when we talk about this, what do you say? Um, the fact that it has been made optional, whether you use that rubber stamp or not, it's completely up to you. If you don't use a rubber stamp, that's also fine. But if you want to use the rubber stamp, you have to accompany it with the signatures. The next is regarding dividends and reserves. How do you pay out dividends? Because dividends, the only account from where you can pay out dividends is your profit account. And that dividend paying is an act that you have to do with respect to your shareholders. Now, we are not talking about the dividends that are given to preference shareholders, because preference shareholders, regardless of the fact that, what do you say, um, uh, regardless of the fact that the company decides or doesn't decide in a certain financial year, they're supposed to get dividends each and every year, and that is something that they have, what do you say, they have contracted with the company in lieu of voting rights. The preference shareholders usually don't vote. So by name, it's a share, but the way it actually behaves, a preference share, is more like a debenture, more like a debt capital instrument, a debt instrument. So dividends and reserves, what exactly is it? Uh, what exactly would be the functions of those accounts will be mentioned in the articles of association, accounts, etc., as well as winding up and indemnity. These are the clauses that would be mentioned within the articles of association. But obviously, it will be taken recourse to with respect to the law of that particular company. Now, the next is with respect to signing of memorandum and articles. Rule 13 provides for signing of memorandum and articles, and it would be signed only in the manner which has been prescribed. So, memorandum and articles of association of the company shall be signed by each subscriber to the memorandum. The name, address, description, and occupation, if any, are to be added. One witness has to be there. This is true for companies which are normally private or public. The idea is, when you talk about an OPC, a one-person company, things may differ. From company to company, specifically, the procedures may differ. Now, the next is with respect to particulars of every subscriber. What exactly is, who exactly is it that's buying the company's share, or if the particular share has been bought by a company itself, not an individual, all of those data has to be maintained with the company, particulars of every subscriber, particulars of first directors, that needs to be maintained, registration. All of these are very important for articles of association because the first shareholders of the company, the members, because in a public company, you need a minimum of 7 members. In a private company, you need a minimum of 2. So all of those 7 members who will initially be a part of the company, and they'll promote the company, they will get the company documents registered with the ROC. All of these, those 7 members, their signature, their details need to be mentioned. Supposing if one of them happens to be a minor, then it would be a problematic situation because a minor is not competent to contract. So all of these concepts are something that need to be mentioned. Okay. When we speak about any acts that override or the memorandum or the articles, if there's anything you do to override it, that would apparently not stand, because memorandum and articles for a company are the constitution and the bylaws and the laws of the company. You can't go beyond it. You can't even regularize the act by taking a board resolution later on. You can't even regularize the act by incorporating it by amending your articles later on. So either you do that first, that is amending your articles or taking out a board resolution before, or you don't do it at all. The whole idea of this uh, acts that override, it's actually very difficult for those acts to stand and make the company liable for those acts, because clearly they are outside the purview of powers of that particular company. And what is the effect of memorandum and articles? Section 10 provides that once the memorandum and articles are registered, they shall bind the company and the members thereof of the same to the same extent as if they respectively had signed by the company and by each member. And they would be all monies payable by any member under the memorandum shall be a debt due from him to the company. So the whole idea of contributories is that every time that I invest a certain amount of money to the company to buy certain shares, that particular amount of money is actually a debt that I'm giving to the company. Why? Because at the time of winding up of the company would have to pay to the contributories, which includes the members, the ones who have, in fact, contributed to the capital of the company. So, this contribution, this amount of money that the company has to return, that's actually an evidence of the debt. It's not something that there is a mandatory redemption period for those debts, as opposed to debt instruments, which are either your deposits, debentures, etc. The idea is that in an equity capital, in an equity instrument, there's no redemption period that's associated. Preference share has a redemption period, but not an equity share. So in such cases, those shares would only be paid off by the company, provided the company has got the money still, and the fact that at the time of winding up, when it has paid all its creditors, first workman salary, then your what do you say, financial creditors, your operational creditors, secured, unsecured, preference shares. After all of these people have been paid under the waterfall mechanism of IBC, do you come to equity shareholders for paying the amount of money that the company would owe to them based on the number of shares that they had bought, fully paid up shares that they had bought, and that amount of money has to be paid. So at the time of winding up, if there were shares that you held which of the company which were partly paid up, company is very well within its rights to call upon the remaining amount of capital from you, because now since the company is winding up, you're supposed to pay off the entire amount. And once you have paid up the entire amount of money, because that's your debt, after that, when the company will issue out money to its contributories, you will be one of them in line to pay off. Now, there are various procedures. One of the procedures for altering memorandum is under Section 13. So, all of these things are done usually on special resolution basis, where you can call upon your shareholders, ask them to vote by special resolution, and through special resolution, will you pass that resolution in order to change or amend that memorandum? Only member have a right to participate in divisible profits. The next is with respect to alteration of articles, which has been similarly provided under Section 14. If you look into the fact how exactly is alteration of memorandum done, that's all mentioned here. The whole procedure as to which form needs to be used, how much money has to be paid, what is the kind of resolution that's required, everything. Now, Section 19 talks about subsidiary companies cannot hold any shares in its holding company. You can have holding companies which have majority shares of the subsidiary company, be it a parent company, be it a holding company, anything. But with respect to a subsidiary, you can't have a subsidiary holding any shares in the holding, because that would amount to a conflict of interest for that matter. So, conflict of interest, to avoid it, this is what you have to do. Service of documents. Section 20 provides that a document may be served on a company or any officer by sending it to the company or the officer at the registered office of the company by registered post, or by speed post, or by courier, or by leaving it at its registered office, or by means of such electronic or other mode as may be prescribed. And secondly, the document may be served on the registrar or any member through electronic transmission. The term of electronic transmission are these, where you talk about a fax, an email, etc., all those electronic messages. Authentication of documents is the common seal, which I was talking about under Section 21. And execution of bills of exchange. Hundi is no longer a very valid negotiable instrument, which we will be dealing when we discuss about NI Act. But Section 22 of the Act basically provides for a bill of exchange, a promissory note, and the fact that it would be deemed to have been made, accepted, drawn, or endorsed on behalf of a company if it was done by a person acting under its authority, express or implied. So if the company has in fact, see, every single time a company writes a check and that particular check has to be endorsed or say written by a particular person, that particular check, what if it bounces? What are the things that you have to prove? So in that case, when, say, supposing the company has made a check to me because I supplied certain goods to the company. So that particular signature of the company, or the fact that company has in fact given me the check, how will I prove that I was actually the good title holder to that particular check and the check was made bona fide to me? So every single time there's a Section 138 claim under the Negotiable Instruments Act, you will first have to go and you have to say that I was eligible to get the money on this check, which I have not because the check has bounced. Bounced for what? Bounced for reasons that the company doesn't have money in its account. So this is a fraud. This is a criminal offense under the Negotiable Instrument Act. So how do you take care of it? So first, when you file the case, it's a burden of proof is on you. How did you get the check? If it was an unlawful way, means in which you have got the check, then it becomes very difficult. Because in such cases, the check will not be something that you will be able to use henceforth. The fact is that you can't claim money on a check which has been issued to you under an act which is unlawful. If I kill someone and somebody has given me a check for killing someone, so if the check bounces, I can't go and say that I'm supposed to get paid for it, because primarily the amount, the kind of work that you have done is in contravention to the law. Similarly, if you've got a check for gambling, so in such cases, you can't say that this is out of gambling and I need to get the check in cash. So the first burden of proof to show that you're a bona fide holder is on you. And then comes whether or not the person who has made the check uh, did so knowingly, knowing fully well that the money was not there in the account. He'll be given time to furnish the amount of money, etc. So as a person who is authorized, if one company is to make a payment to the other company, how do you know who's the one who's signing the check on behalf of the company? Or how do you know who's the one who's collecting the check on behalf of the company? So the person, in either of the cases, needs to be a person authorized by the company. How do you understand the authorization that has been given by the company? If you are a director of a company, how will you prove that you are the director authorized by the company? So there's one very specific way, is that you provide the people with the court with, or the police also for that matter, with an authorized board resolution copy, and say that this is where I have been authorized by the company to be a director, to sign on behalf of the company or to collect money on its behalf, and thereby I am the one who's claiming under this section 138 of the Negotiable Instruments Act for the dishonor of checks. So the whole idea is that this authority for executing bills of exchange or for authentication, that is a matter of indoor management, because board meeting proceedings or board resolutions are not a public document. Board resolutions, board meetings, they need to be registered with the ROC, but they're not public documents as such. They are not something which are up for inspection, even for the shareholders for that matter. All that they need to know, the shareholders that they need to know, is that specific number of board meetings have happened over the year, and that is in compliance with the Act. Now, whatever resolution is passed, that is something that will be discussed, that will be taken forward by the managing director, whoever the person is authorized, take it forward. But beyond that, a company has no duty to make those board resolutions a public document. So in such cases, if you have been authorized in one such board resolution, how would you prove that you were so authorized? Because unless and until you provide them with a board resolution copy, there is no way for anybody to know that you actually were appointed in such a position. So with respect to other regarding your registered office of a company, verification of a registered office, publication of the name by the company, change of name of company, situation, change of the registered office of a company, or shifting the same. These are very much a part of your concept where uh, uh, oppression mismanagement can happen. Supposing in under section 241 also, there is this one particular case whereby there are two groups of shareholders who apparently had a problem with each other. And the person who was in control of the two groups, two different persons, they had their own nominees within the company. and they were the ones who were supporting them. So one of the shareholders group, because they were in majority, they tried to hold meetings of the board, and they tried to conduct the meetings of the board, and they tried to what do you say, furnish these what do you say, they didn't furnish any notice to the other party, even though both the people were the brothers in a particular company. They didn't give any notice, they didn't give anything to that particular brother, and eventually they had changed the registered office of the company. So there are all sorts of official communication reaches to their registered office and not to the original registered office. So each and every step that was actually being taken by one group of shareholders was actually oppressive against the other, and which is why there was an oppression mismanagement claim and they won. So all of these clauses, they have to be changed with the full consent of all the shareholders with a special resolution, etc., because it affects the entire gamut, the entire community of shareholders of a particular company. These are your procedural, procedural discussions. The next topic is we begin with public offers. Let's take a 10-minute break and then we can come back and resume with public offers. Okay. So we resume from public offers. Let's discuss about what a public offer is, and then we can move forward with the remaining. Every single time that a company requires to raise capital, there are multiple ways of doing so. If it's a public company, it can go about making a public offer as well as making a private placement where you can choose your shareholders. There are multiple ways of uh, doing the work of raising capital. However, with respect to a company that is a private company, private placements happen to be the only way in which you can raise capital. We are not discussing about rights issue and bonus issue here just as yet. We are just talking about public offers and private placements, which is the opposite of public offers. What exactly does Section 23 talk about with respect to a public offer? So it clearly mentions that issue of securities by a public company. So there are various ways in which there are many procedures that you have to fulfill in order to issue out shares for a public company. One of the first is that you have to issue a prospectus. A prospectus is mentioned under Section 25, 26, etc. It's basically an offer document which you have to show to people, which will be relied on by them. And thereafter, it will be, uh, what do you say? It would be given to the potential investors who can then decide, make an informed consent as to the fact whether or not to invest in that particular company. So this is a prospectus, which is a part of your public offer. The next is with respect to your private placements. Private placements are basically with respect to your uh, choosing shareholders, where each and every shareholder, the one that you want to place your shares to, you want to give your shares to, you are basically asking them to buy the shares in your company, but you're picking and choosing them. You're not making a general offer. So the fact is that you are, whenever you as a company, you decide to make a public offer, the whole procedure is something that's mentioned in the issue of capital disclosure requirements regulation of the company. Second. When you talk about the issue of disclosures that you require, issue the capital disclosures, etc., it talks about the whole prospectus. Talks about the public offer procedure. The first is that the company decides whether or not to issue out shares, which is decided in the general meeting. Eventually, when the company has decided that it would actually go forward with issuing out shares, then they would have to give out your uh, an advertisement for inviting upon merchant bankers, entities who would like to be merchant bankers for the company's public issue. Then you choose a merchant banker. It can be multiple merchant bankers also, depending on the size of your issue. And the lead merchant banker is the one which is chosen amongst those merchant bankers. And this merchant banker will now will help you locate other intermediaries who are going to help you with issuing out your shares. So the other intermediaries could be your banker to an issue, your CACS valuers, your what do you say, the uh, stock exchanges, the brokers, every single person that you can think of who will help you with this public issue. They will all be they will all be appointed by you as a company, but underwriters, etc. All of these people will be brought forth to you by this merchant banker or the lead manager, and they will ask you to appoint them. Then after that, what happens is that you go ahead and draft a prospectus along with your merchant banker. Your merchant banker will help you make that prospectus. However, it will be signed by you, but the expertise, etc., would be of many different people: solicitors, experts, valuers, anything, civil experts, so many different people. Thereafter, you make that prospectus and register it with the SEBI. SEBI is going to look into the prospectus and determine if all the particulars that it has asked of you, whether or not you have fulfilled it. If you have not fulfilled it, SEBI is going to ask you to complete the particulars that are required. Now, SEBI is not going to check the authenticity of the things that you have actually furnished. SEBI is not actually, if you write that I have 5 factories, SEBI is not going to conduct a survey of, SEBI is not going to go into an examination of the facts whether or not you actually have 5 factories or not. SEBI is only going to see, okay, you have mentioned that you have 5 factories and that's about it. But what SEBI is going to do additionally is they are going to publish it on their website for 45 days. Now, within those 45 days, if there are people who have a problem with the way that you have mentioned your particulars because they are not true, then in such case, SEBI can take it up against you. Because such falsification of information is something which is not allowed. So once you have got a green signal from SEBI, and once there is no case, etc., that is undertaken against you or your disclosures as such, in such cases, they will be asking you to uh, register it with the ROC. And upon registering it with the ROC, you can actually go and open up your issue. Once you open the issue, if it's a bidding procedure that you have chosen, then there'll be 3 or 4 days of bidding that would take place, and based on which you will actually be choosing the shareholders, the cutoff price, basically the investors who have bid the highest, because your main motto as a company is to place the maximum shares at the maximum price. Once you have done that, then you sell those shares, and you will have to then afterwards get that particular amount of money transferred to your paid up capital. Until and unless the issue has in fact materialized, you will have to keep that in an escrow account. Escrow account is an account which is maintained with a banker to an issue. And based on that, once your minimum subscription has reached, the amount of money from the escrow account will then reach to your paid up capital account. And based on that, will you begin with your operations as a company. And the only thing that will be left afterwards is allotment of shares and listing. So once you have done both of them, your entire public offer comes to an end. So the main purpose of a public issue happens to be listing, which you have to achieve. Once you have done that, there's nothing more that's required anymore. Now, when we talk about a public offer, we talk about what exactly is it that has been laid down for a private company. Private placements also, when you're picking and choosing your investors, your shareholders, the thing is that the disclosure still has to be made, because at the time of giving my money, I need to know what am I giving the money for. So unless and until you know that, it will be very difficult for you to ensure that you are not making an investment in a wrongful place, for that matter. So in such cases, this amount of money needs to be paid for these purposes. So prospectus is what is required for a public offer, whereas there is a document that's required for a private placement also, which is there in your you have your LODR, listing obligations and disclosure requirement norms. Then you have multiple other legislation which talks about the disclosures that needs to be made in a prospectus, in an offer document, which is other than a prospectus, in private placements, that is. So all of these are something. There are various kinds of prospectuses. There's a red herring, there's a shelf, as well as there is a normal prospectus. Basically, shelf prospectus is a prospectus where the validity of a prospectus remains for a year, 1 calendar year. So no matter how many number of times you want to go for a public offer, the same prospectus will do, because you registered it once. You don't have to go through the whole procedure of drafting of a prospectus, etc., again and again, and the whole procedure of going with SEBI and all of that, because that is less hassle. But the only thing is that if there is a change in your company's capital structure or anything for that matter within that 1 year, you have to attach it, annex it with an information document to that shelf prospectus. So that's the only compliance. Whereas when you talk about a red herring prospectus, a red herring prospectus is basically a prospectus which is used where the disclosure is not complete with respect to either the size of the issue or the price of the issue. So in such cases, if either of it is not known, it becomes easier for you to bid, and based on which the company will decide then at what price should they sell the shares, or how many shares should they actually sell at what price. So through the bidding, it's usually very easy for the company to reach a conclusion. That's a book building method. Variation in terms of contract or objects in prospectus. It can vary. However, all of these have to be done only with respect to your special resolution. So that's mentioned under Rule 7, subsection 1. Then you have your dissenting shareholders who will be allowed to leave the exit the company. Offer of sale for shares, which has been mentioned under section 28 with respect to what happens to the shares of a company which is to be sold by the members of the company. So if the members wanted to sell a part or full of their shares to the public as such, then in such cases, how would you determine the price of the shares? This is not a mere sale, as in, what do you say? The secondary market over the stock exchange. This is offer of sale, which is undertaken by the company on behalf of its members to sell the shares amongst the members of the public. Dematerialization is something that is very important. Section 29, it's mandatorily dematerialized. So none of the shares today, as on today's date, have physical form of shares. There are many reasons why dematerialization happened. Mutilation, forgery, many reasons why dematerialization, electronic form of checks is actually a very good thing. Automatic updation with the depositories, many different things. Advertisement for prospectus. When you are going ahead with the prospectus, you need to advertise it. That I'm going for a public offer. If you want my prospectus, you can buy it from, say, State Bank of India ATM, branch somewhere. So this is a notification. So if I wanted to see a prospectus, which is a detailed disclosure, I have to go to, say, SBI, and I have to buy your prospectus. So this is basically your advertisement for a prospectus, but that is not a prospectus, but there's a certain format to it. Application forms where you have to purchase the shares, but usually application forms are attached with that particular prospectus. It's a share application form, which after you have read the entire prospectus, do you fill it up and then tear it and give it to the bank, the banker to the issue. Nowadays, you can do it through your demat accounts, your broker accounts, basically. So if you wanted to buy shares, you can do it through your Zerodha account, etc. So many different accounts are there, angel broking, etc. And then you can buy those shares, any sort of dematerialized account that you maintain with your broker. If you have misstated something as a company in the prospectus, then the entire liability would be that of the particular director first. And secondly, the persons involved in making that sort of a disclosure, the experts. So criminal liability mostly is on directors and merchant bankers, whereas civil liability is basically on an expert. So you have promoters, etc., who are all criminally, who can be made criminally liable, but depends. The mental intent is something that is very important to be determined with respect to the misstatement liability, whether it's a criminal or a civil liability. And finally, we talk about punishments for impersonating and fraudulently getting people to invest in a particular company. Now, allotment of securities is also very important. If a company has had an oversubscription where you have only 100 shares to be sold,